Hello everyone, a very good morning to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So before starting this session, I would like to say you that today is the 10th of January, right? Today is the 10th of January and your new batch, that is a resolution batch of CIB exam 2024, is going to be start from today. So in this batch, you can see that this is a full-fledged batch. It's a foundation, just kind of foundation batch, in which ABM, ABFM, BRBL, and BFM, these subjects will be taught by you. Okay. So in this compulsory subject, you will get the live classes of the compulsory subject. Okay. And suppose if you miss any live classes, you can see the recorded session here. Okay, the recorded sessions are available. After that, you will get the mock paper in this batch. Then doubt session will be there, and there will be the questions that will be given by the teacher in each module. So that's why this is very, very much important from the examination point of view. So if you want all these things, you have to enroll in this batch simply by applying the coupon code Y391 for the maximum discount up to 80% that is going on. Okay, this batch will not include the elective subject. So if you want an elective subject now, you have to purchase the video courses of a particular elective subject, okay, whether it is HR, IT, risk management, etc. So this is very, very much important. So do not forget to enroll in this batch by applying the coupon code by this one. Okay, now this is your module B. Let's start with the session. These are the act. These are the act that we have to study. Okay, number one question. Hypothecation is what? A transaction of conditional sale, a legal transactions whereby goods may be available as security for debt, transfer of ownership by borrower to the lender, and none of the above. So which of the following class that is a right one? Tell me. That is important. If I say you, many students, confuse between the hypothecation and the pledge, right? Hypothecation and the pledge. So what is the basic difference between hypothecation and the pledge? In the pledge class, the A person transferred property to the B, okay, as a security. In the pledge, A give the possession of the property to the B person. But in hypothecation, the difference between pledge and this is called implied pledge. Hypothecation is clause simply a implied pledge. Okay. So in hypothecation, what happened? Suppose A and B is there. A want loan. So B will give loan. But in this case, A will not give the possession to the B person. He will not give. So the possession will be in the hand of A person. Okay. The ownership paper, that is the document of the car, will be in the hand of the B person. So this is the basic term of the term hypothecation. Okay. So now you know the exact difference between hypothecation and pledge. Now tell me whether it is transaction of conditional sale, the legal transactions whereby goods may be available as security for debt, transfer of ownership by borrower to the lender, or none of them. Tell me, class. Which of the following is the right answer for this question? Do not forget to subscribe the channel of Officer Adda 24/7. Hanji class. What is the right answer? What is the right answer? A very good question. The term hypothecation, the term pledge, hypothecation, pledge is there, then set off, lien, mortgage, assignment. These are the part of important terms that is mentioned in module B. Hanji class, which of the following is the right answer? So hypothecation is nothing but a legal transaction whereby goods may be made available as security for the debt. So for the first one, B will be the right answer. Okay, which of the following is the right answer? B is the right answer here. Okay, that's it. Next one. Hypothecation is a mode of security provided in what? Indian Contract Act 1872, Transfer of Property Act 1882, Banking Regulation Act 1949, or SURFACE Act 2002. Which of the following is the right answer? Tell me. Hypothecation is the mode of security provided in what? In which act this is given? I'm just giving you the hint. Section 2 clause N talks about hypothecation. Now you tell me which act? Indian contract. Indian contract is basically general principle of contract and special principle of contract. This is there. Transfer of Property Act is basically in which we have to study the mortgage, lease, sale, etc. Banking regulation, how to regulate the bank. But this SURFACE Act, D, this is the right answer. SURFACE Act, Section 2, Clause N talks about this one. Okay, so this is the right answer for this question. Second one. Okay, this is the right answer for this question. Section 2N. Now, loans obtained against hypothecation of an asset is called what? Unsecured loan, capital, secured loan, and all of the above. Tell me, class. The loan obtained against the hypothecation of an asset is called what? Unsecured loan, capital, secured loan, and all of the above. Which of the following is the right answer? This is a good question. Okay. Loan obtained against hypothecation of an asset is called what? So this is secured loan. What is the difference between secured loan and unsecured loan? Secured loan is basically just like pledge, mortgage, in which we are giving something property. Unsecured personal loan, educational loan, in which we are not giving any security. So this is the basic difference between the secured and unsecured loan. So that's why the loan obtained against hypothecation is called the secured loan. Third C is the right answer. Okay, next. Which of the following mortgages can be made without writing? So guys, section 58 clause A talks about the definition of mortgage. And there are 6 types of mortgage that is defined in the TP Act. So tell me, which of the following mortgage can be made without writing? It is equitable mortgage, English mortgage, simple mortgage, and usufructuary mortgage. Tell me, class. Which of the following is the right answer? Without writing. Equitable mortgage is also known as mortgage by deposit of title deed. Okay, this is equitable mortgage. So if you just remember the quality of equitable mortgage, because this is the right answer, it is that mortgage that is given without registration. Only in metropolitan areas this mortgage happen or any state government notify. So this is the important thing about this one. So for the fourth one, the right answer is equitable mortgage, because in this we only have to deposit the title deed, that's it. So fourth A is the right answer. Okay, next. In which of the following mortgages the mortgagor is required to deliver the possession of mortgage property to the mortgagee? In the English mortgage, conditional mortgage, usufructuary, anomalous mortgage. Class, anomalous mortgage is that types of mortgage that is a different combination of. It's a different combination of mortgage. What is usufructuary mortgage? Usufructuary mortgage is basically in which we just give the possession and the mortgager is not personally liable. The mortgagee will take money by taking the rent and profit from the this one. That is called usufructuary. Mortgage by conditional sale. Mortgage deed will be automatically converted into the sale deed. This is called conditional. And English mortgage, certain date is decided when they have to give. So the mortgage in which, you know, delivery of possession. So this is your usufructuary mortgage, because in usufructuary mortgage, suppose this is mortgager, this is mortgagee. Two parties are there. So the mortgagee cannot say to the mortgager to give the money if he is not able to pay the money. In that case, whatever the property that the possession is given to the mortgagee, so the mortgagee will take the rent and profit from that property. Then only this type of mortgage can be taken place. So for the fifth one, C will be the right answer. Okay, C will be the right answer. Next, possession under anomalous mortgage may be delivered, may and may not be delivered, and none of the above. Tell me, class. Important one. हाँ जी class. Possession under anomalous mortgage what? May be delivered, may or may not be delivered, or what? So anomalous mortgage, the definition is different kind of mortgage is called anomalous mortgage. It is not a simple mortgage, conditional, etc. So the possession in anomalous mortgage, it's may or may not be delivered. Sixth, B is the right answer. Okay, B will be the right answer for this question. Next. Under which of the following mortgages the lender gives money to the borrower in the form of installment? First of all, this type of mortgage is not written in your TP Act. It is reverse mortgage, anomalous mortgage, equitable mortgage, usufructuary, land back mortgage. What is the right answer? In which of the following mortgages the lender gives money to the borrower in the form of installment? First of all, I have told you that is not given in the TP Act. So the TP Act, this is not there. This is TP Act there. TP Act, TP Act. So in the TP Act, these three types of mortgage are there. But the reverse mortgage and the land back mortgage is not there. So your answer should be from this and this. Tell me class, the right answer. The answer is from which of the mortgages the lender gives money in the form of borrower. The right answer for this question is reverse mortgage. Seventh one is the right answer. Okay, next. And mortgages his 2 BHK flat to a money lender in return the sum and the lender decided to let flat on the rent. This is example of which type of mortgage? Equitable, usufructuary, English, fixed rate, none of the above. Eighth, what is the right answer? Tell me class. The man mortgaged his 2 BHK flat to the money lender in return of a sum of money and the lender decided to let the flat on rent. So this is example of which type of mortgage? This is the example of a very simple term, usufructuary mortgage, because in usufructuary you have to use the term use and profit. This is the right answer. Next. In simple mortgage, possession of mortgage property given to mortgagee, given to third party as security, remains with the mortgager, none of the above. Tell me. Ninth one. In simple mortgage, the possession of mortgage property is given to the mortgagee, given to the third party as security, and remains with the mortgager. In the simple mortgage, always remember it is remains with the mortgager. C is the right answer for this question. Okay, next. Redemption arises in the case of what? So first of all, what is redemption? First of all, gift means if we are giving any property to the another person without taking any money, that is called gift. Mortgage, we are giving immovable property as security, that is called mortgage. Lease, we are giving the possession of immovable property, that is called lease. Exchange, we are exchanging one thing to another thing, that is called exchange. So redemption is basically when mortgager give the money back to the mortgagee. In this case, he have a right to take back his property. So take back his property, that is called redemption. So that's why for the 10th one, B will be the right answer. This is called redemption. Hello everyone. A very good morning to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So this session is very much important from the examination point of view. So we have already done module A and right now we have to do the module B. Okay. So let's start the session of your module B. So before starting this session, I would like to say you that our new batch of this session is already started and the batch name is resolution batch. As you can easily see in the resolution batch, the four compulsory subjects are attached here. Okay, you will get the live classes of this four compulsory subject plus recorded session if you are not able to see the live classes. Okay, so the live classes are available, recorded sessions are available, then mock paper are available, doubt session, okay, ebooks. So I think this single paid batch is sufficient to crack your exam. Okay, and after that in bilingual also the Shapat batch is started. So if you want to take the batch in the bilingual language, you can take the batch in the bilingual language also. Okay, now let's start with the question and answer of your module B. Yeah, what does PMLA stand for? It's a Prevention of Money Laundering Act, Protection of Money Laundering Activities, Prevention of Money Laundering Activities, or Projection of Money Laundering Activity. Which of the following is the right one? Hanji class. What is the full form? Because in the December session, the one question has been come from the full form. So that's why this is important. So for this thing, the right answer is Prevention of Money Laundering Act, which is made in 2002. So A is the right answer. Okay, next. The obligation of banker, it's a banker, to honor his customer check is extinguished on receipt of order is known as what? Banker order, garnishing order, RBA order, or debtor order. Tell me, class. It's the banker. Hanji. What will be the right answer for this question? The obligation of a banker to honor his customer check is extinguished on receipt of the order is known as what? I think all orders are easy. What is RBI order, debtor order, bank order? But I think you don't know that what is the garnishee order. So I'm just giving the one example to understand the garnishee order. Suppose X have to give 10 lakh rupees to the Y person. Okay. But right now he is not able to pay the money. X person working in a company. Okay. So, and the source of income of X is this company. So the court will order what? This company. That suppose the salary is 10 lakh rupees per annum. So the court will order that you have to deduct 10% of the amount from his salary and you have to give it to the Y person. So the order which is given by court to the company, that is called garnishing order. So the court order to the company to deduct 10% salary, then the salary will be kept to the Y person. This is called what? Garnishee order. So basically, in that way, the Y will get the money. So this is very, very much important. Is that clear? Okay. So I think this is easy one. Now, The word person defined in the Money Laundering Act includes what? The word person that is defined in the Money Laundering Act includes what? The first is Hindu undivided family, the family which is in joint. Every artificial judicial person, an association of person and the body of individual, whether incorporated or not, and all of the above. So, what is the right answer? Yes, class. Person. The definition term is very important from the examination point of view. Definition term always come. Definition term always come in your exam. Hanji class, what is the right answer? So class, according to this definition, the person include Hindu undivided family also, this person, association. So that's why all of the above will be the right answer. All of the above will be the right answer. Next. Which of the following is not prescribed in the provision of prevention of money laundering? Okay, which is not prescribed. It is a seizure of property, attachment of property, confiscation of property, or life imprisonment. What is the right answer? What punishment you can say that is not defined in the act? Seizure of property, attachment of property, confiscation of property, or life imprisonment. What is the right answer? See, in the Prevention of Money Laundering Act, we just basically take the money, okay? That is a illegally. So in that case, life imprisonment is not included in this one. So for the fourth one, D will be the right answer here. Okay, D will be the right answer. Whoever commit the offense of money laundering which relates to any offense specified under paragraph 2nd of part A of the schedule shall be imprisonment, that is a rigorous imprisonment for a term that shall not be 3 years, which makes 10 to. Okay, that is good question. That is about the punishment. Whether it is 3 year, 5 year, 7 year, or 10 year. What is the right answer here? Fifth one. Whoever commit the offense of money laundering which relates to the any offense specified under paragraph 2nd of part A of the schedule shall be the punishable with the rigorous imprisonment for a term which shall not be less than 3 years but which may extend up to, the right answer will be 10 years. This is the right answer. Okay, now under section 5 of prevention of money laundering, property can be provisionally attached for a period not exceeding dash from the date of order. It is 60 days, 90 days, 120 days, or 180 days. What is the right answer? As per Section 5 of this Act, the property can be provisionally attached for a period not exceeding, that is 180 days from the date of order. So 6D is the right answer. Okay. Each question is class very much important. Now, the appellant tribunal pass an order against Mr. G. Mr. G is the aggrieved by the same. He wants to file appeal against the order passed. Now tell me to whom he can appeal against the order of appellant tribunal. Adjudicating authority, High Court, Supreme Court, or Parliament. What is the right answer? Yes, class. The appellate tribunal passed an order against Mr. G, and Mr. G is aggrieved by the same. So you have to tell me he can appeal against the order passed by appellate tribunal against adjudicating authority, High Court, Supreme Court, or Parliament. The right answer will be that is High Court. B is the right answer. Okay, next. EF Limited, a company found guilty under the provision of Prevention of Money Laundering Act. Okay, this is a company. Mr. Ved was one of the director who was responsible for the business of company when the crime was committed. Okay, so here are two-person name, EF Limited and Mr. Ved. Okay, after that, later he resigned. Okay, shall he be deemed to be guilty of the contravention and be liable to the proceed against and punish accordingly? Advice say yes or no. In the first sentence, it is written that the company found guilty under this act. Mr. Ved is one of the director who was responsible for the business of company when the crime is committed, and later he resigned also. This is a factual based question. So shall he deem to be the guilty of contravention and liable to be proceed against and punished accordingly? Say yes or no. As we know that the company have a separate legal entity, okay, apart from its member. It means for the death of the company, the members are not liable, and for the death of the member, the company is not liable. So what is the right answer? The right answer will be yes, he will be liable. Okay, for the eighth one, A is the right answer for this question. Done. Next. Okay, I think this is not the same question. Okay, yeah, This is a different question. This is a company found guilty under the provision of prevention of money laundering that we have read. Mr. Ved was one of the director who was responsible for business of the company when the crime is committed. Later he resigned. During the proceeding, the said act, he proved that, okay, in the proceeding class, he proved that the contravention took place without his knowledge and he exercised all due diligence to prevent such contravention. Shall be deemed to be the guilty of contravention and liable of the proceed against the punish accordingly. Advice. Yes or no? A very good question. This is not the same question. This is not the same question. In the previous act, this sentence was not there. Okay. But in this case, this paragraph is there. So for the right one class, the right answer will be B is the right answer. Okay. Now, Mr. X convicted as per provision of prevention of money laundering but under Contract Act, he is not guilty. Under the circumstance, what will happen if there is a conflict between PMLA and other law? Important one. This is PMLA and this is other law. Who will supersede? Decision is taken as per severity of the crime committed. The provision of prevention of money laundering have overriding effect. Notwithstanding anything inconsistent contained in any other law for the time being in force or not applicable. What is the right answer for this question? For the 10th one, the right answer is the provision of prevention of money laundering has an overriding effect. Okay, so B is the right answer. Hello everyone, a very good morning to all of you. Welcome to the Officer Adda channel of Adda 24/7. I hope so you all are fine. So first of all, happy Makar Sankranti to all of you. May God bless you and just give you the fruitful success in the CIB June exam 2022. So guys, in this session, that is a question session, we are doing the questions of module B, and this week the module B will be go on, and after that module C and D is left. That is a very important part of your exam. Okay, so now let's start with the session. Before starting this session, I would like to say you that today is the last day of the sale. Okay, if you want to enroll in the resolution batch, okay, if you want to enroll in the resolution batch, okay, so in the resolution batch you will get the 4 compulsory subject of your CIB exam. It will not include the elective subject, so it will include the 4 subject in which the live classes will be go on. The recorded session of the live classes will be there, recorded session done. After that live class recorded session, you will get the ebooks of each compulsory subject. You will get the mock paper. You will get the doubt session here. So these are the 5 things that included in this resolution batch. The teacher will take the live class according to your time. The timing will be always 6 to 9 a.m. Okay, 1 hour for each subject, and at the evening it's a 7 to 10 p.m. This will be the timing of the live classes. Is that okay? Now let's start with the question and answer series of the module B. So module B, as you know that it's contained 1, 2, 3, 4, 4 act plus this one. Okay, now the first question on the screen is that what was the motive to bring the Payment and Settlement Act into being? To provide for the regulation and supervision of payment system, to designate RBI as authority, matters connected therewith, and incidental thereto, and all of the above. What will be the right answer for the first question? Tell me, guys. As we know that if we just compare the old days, so whenever we just do the transaction, the barter system was on the way. Barter system. In the barter system, if you will give one thing, you will get another thing from the another party. After barter system, you can say the documents come. Through documents, we just transfer the money and the things. After documents, rupees come into picture. And after this rupees, now we just use the online way. Okay, we just use the online way to transfer the money from one person to another person. Okay, from one person to the another person. The barter document means you can say the check, promissory note, bill of exchange. After that, the rupees, and then the online thing in which we have to do. Okay, so after that, you can see the act is made. The Payment and Settlement System Act 2007. You know, in the December exam 2023, this question was asked that the Payment of Settlement System Act was of which year? So you have to take mark on the 2007. Okay. Now, what is the basic motive behind this act? And C class in the Payment and Settlement now, RBI is one of the main regulatory body here. So its basic aim is to provide for the regulation and supervision of the payment system, to designate RBI as authority, matter connected therewith and incidental, or D, all of the above. What will be the right answer here? Aji class. So for this thing, the right answer will be, that is the D is the right answer. Okay, D is the right answer for this question. Done. Now, what does bank means in the Payment and Settlement System Act unless the context otherwise require? A bank included in the second schedule to RBI Act, a post office saving bank, a banking company as defined in clause C of the section 5 of the Banking Regulation Act, or all of the above? That is good question. 100 class. What will be the right answer? What does the bank means in the Payment and Settlement System Act unless the context otherwise required? What is the right answer for this question? Bank that is included in the second schedule to the RBI. What is schedule? Schedule is also just like a this one section. Section means the provision of the act. So schedule are same thing. B, post office saving bank and the banking company. The right answer for the second question is, that is D. This is the right answer for this question. D. Is that okay? This will be the right answer. Next. What does derivative means in the Payment and Settlement Act? An instrument to be settled at a future date, a payment to be settled at a future date, an instrument that has already got settled, or none of the above. Second class. What is the right answer? Derivative. If I say you the derivative meaning in the banking point of view, it is a financial contract whose value is derived from the performance of underlying market factors such as interest rate, currency exchange rate, commodity, credit, and equity prices. This is the right answer. So what does derivative means in this one? If I say you the this is the right answer. A. An instrument to be settled at a future date. So this is the right answer. Okay. Next. Which section of PSS Act define payment system? Now in this time I will say that you have to learn some sections. So what will be the right answer? Section 1, Section 2 clause 3, Section 2 clause 1 or Section 3 clause 1. What will be the right answer? Hanji class. Which section define the Payment System Act? The section-based questions are always important. The section-based questions are always the important one from the examination point of view. So what will be the right answer? For this one class, the right answer will be that is C. C will be the right answer. Okay, next. Which of the following is included in the payment system of Payment and Settlement System Act? Clearing, payment, settlement service, or all of the above? What is the right answer for this question? Clearing is basically the process of settling transaction between the banks. Okay? Clearing means the process of settling transaction. That is called clearing. Okay? And payment, you know what is payment? And settlement means the transfer of the process of transferring funds to the central agency from payer to pay through participation of their respective bank and custodian of the fund. This is called bank settlement. Okay? Transaction on the behalf of someone who received payment. So settlement bank, you can also say that the bank can also be the settlement bank. So for this question, each point is written in your act. Okay? Now, what is hypothecation class? What is hypothecation? A transaction of conditional sale, a legal transaction whereby goods may be made available as security for a debt, transfer of ownership by the borrower to the lender, and none of the above. Which of the following is the right answer? Hypothecation. Students are so much confused with the word pledge and hypothecation. So pledge is basically, you can say, when we give the movable goods to the particular opposite party as a security. That is called pledge. In hypothecation, we are not giving the actual possession. We are not giving the actual possession. So what will be the right answer? It is a transaction of conditional sale, Legal transactions whereby goods may be made available as security for debt or transfer of ownership by the borrower to the lender. What will be the item? Yes, class. What will be the right answer for this question? So the hypothecation is basically a legal transactions whereby goods may be made available as security for a debt. This is the right answer. Okay. Next. Under hypothecation, the ownership possession of goods with a bank, ownership borrower possession with a bank, ownership possession borrower, ownership possession this. What is the right answer? What is ownership? Full right over the property. And what is possession? You can say that is only the custody. That is called possession. So hypothecation, what you will say? Always remember, see, suppose if we purchase the car, okay, and Nikita ma'am have taken loan from the bank. The possession will be with Nikita ma'am. Nikita ma'am is also the owner. Only the document will submit to the bank. So ownership and possession is with the borrower. If I say you this one, the ownership and possession is with the borrower. Why class? Because see, Nikita ma'am will purchase the car in her name now, right now. So ownership also, possession also. But you can say the document now. The document will be in the hand of the bank. The document will be in the hand of the bank. So this will be the right answer for this question. Now, Ram, a transporter, has been granted a loan to purchase a truck. You will creating which of the following charge? Tell me. You will create assignment, mortgage, pledge, and hypothecation. Assignment means to assign, like LIC policy. If the premium is paid by the bank, and Nikita ma'am is an assigner, bank is assigning. Mortgage, we are giving immovable property as a security. Pledge, we are giving movable property as a security. And hypothecation, basically, I think if we just purchase any truck, car, machine, etc. So this will be always done in the case name of the hypothecation. So D is the right answer for this question. Okay, D will be the right answer. Next. In Shakuntala Swane versus Kaushalya Swame, the Supreme Court observed that the finest hour of justice is the hour of compromise when the party after it's a burying the hatchet reunite by reasonable and just compromise. Whether this principle has been reflected in ADR procedure that is mentioned in the Arbitration and Conciliation Act. Tell me class. That is good question. Apply in common sense. Apply your common sense here. Yes, class. What will be the right answer here? Tell me. So for this is class, in this question, the finest hour of justice is the hour of compromise when the parties are, after burying the hatchet, reunite by the reasonable and compromise. It means class C. In the case of compromise now, from the court, we never expect the compromise and settlement, but from the ADR, we always accept the compromise and settlement of the case. So whether this principle has been reflected in the ADR procedure mentioned in the Arbitration and Concession Act, this is absolutely yes, because in arbitration also, in conciliation also, the word settlement and compromise is always there. So that's why A is the right answer. Okay, if we talk about the tribunals, Lok Adalat, etc., ombudsman, their aim is to compromise and settlement. Okay, now if the holder of bill of exchange allow drawing more than dash hour exclusive of public holiday to consider whether he will accept the same, all previous parties not consenting to such alliance are thereby discharged from the liability of such order. This, this, and this. What will be the right answer here? Tell me, class. What will be the right answer for this question? Yes, class, tell me what will be the right answer for this question. The right answer is 48 hours. D is the right answer. Hello everyone, a very good morning to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So, as you know that the module B is going on, which is very important from the examination point of view. Okay. So before starting this batch, I would like to highlight the batch that is a resolution batch which is already started from 10th of January. This is the batch in which we just teach you in a very detailed form. Okay. And in this single paid batch, you will get only the compulsory subject live classes. It's recorded session. The live classes will be there, recorded session will be there, mock paper will be there, doubt sessions, okay, and you will be get ebooks. So this is very important from the examination point of view. Okay, CIB June 2024. This is for the batches. Done now. So module B is going on. So first of all, today let's understand a very important term that is in your fifth point. This one. Because see, in the fifth point, what we have to study, that is a mortgage, it's a hypothecation, it's a pledge, okay, then set off, banker's lien, assignment. So these are the six terms that is in the fifth point. So today we will discuss this point one by one. Okay, now first of all, we have to understand this term that is pledge. What is pledge? Powner, pawnee, and this one. C class. If you go through the Indian Contract Act now, that is basically divided into the two part. The first is general principle of contract. The second is spatial principle of contract, right? In the general principle of contract, that is 1 to 75, and spatial 124 to 238 is a spatial principle of contract. In general principle of contract, we basically have to study about the what are the essential points of the valid contract. This was the crux of general principle of contract. But in the spatial principle of contract, we have just learned that we have to study the spatial in which the valid contract is already implicit. So we have to study about the contract of indemnity, contract of guarantee, contract of pledge, bailment and agency. So pledge is one of the part of your spatial principle of contract. Why it is called spatial principle of contract? Because the general principle of contract is already implicit in the spatial principle of contract. So now if you talk about the pledge, so that is very simple term. A is there, B is there. A wants money, so B will give money to A, right? After that, A have to give some, you can say, the movable item as a security, as security to the B person, right? So what is this? When the movable item he just given as a security, so the contract between A and B is called the contract of pledge. In this one, A is called powner, B is called pawnee. A very simple term, powner and pawnee. Okay, it may be, it's just if we just think about the this one, so only possession, possession is given to the bank, and possession is the basically custody, custody which is given to the bank. The actual ownership is in the hand of the pawnee. So this is the crux of your Indian contract act of the pledge. Okay, now if we go through the definition, it is a bailment of goods. Why it is called bailment of goods? Because in the bailment we have seen the definition of bailment, that the delivery of goods from one person to another person for the specific purpose, for the specific purpose. Okay, and when the purpose is fulfilled, we have to give back the goods to the A person. So that's why it is the bailment of good as security for payment of debt or performance of a promise. It is called pledge. So in the pledge, we basically have to payment of debt is there and the performance of the promise is there. Okay, and the bailer in this case is called powner, and the bailee in this case is called pawnee, because this A person in the bailment, that is called this one bailer, and this is called bailee. So that's why the bailer we call as a powner and the bailee we call as a pawnee. So this is the simple definition of the terms. Okay, if you see the example, A lends money to the B against the security of jewelry deposited by B with him. It means in the security we have just deposited the jewelry. So this bailment of jewelry is a pledge as security for lending the money. So B is the pawner, okay, and A is the pawn. So this is a very simple example to understand the term bailment. Okay, so I think this concept is clearly, clear to all of you. And now see the definition 172. At least you have to learn the sections of the special principle of contract, because that is important. Before this, I always just used to say that do not focus on this one, but today I will say that you have to focus on the section also. So if I say you the indemnity, section 126, guarantee, section 120, sorry, 6, this is 124. This is 124, 126. Then after that, bailment, section 148. Then pledge, section 172. And agency, that is section 182. So these are the important terms of the contract, of the special principle of the contract. Okay. And guys, do not forget to like the session, and daily at 7:30 a.m. we just do the this one. Okay, now these are the essential of the pledge. After this, now we will do the this one. We will do the uh, questions of the pledge. Okay, that is important for one. See, since pledge is a special kind of bailment, therefore all the essentials of bailment are also the essential of pledge. We know that. Okay, whatever the essential point of bailment is equal to essential point of the pledge. Okay, but there are certain, some different points of pledge. Okay, the first is there should be the valid contract between the person. So what is the valid contract? We have already learned in section 10 of the Indian Contract Act. The valid contract means between the pawner and pawnee there should be offer, there should be acceptance, there should be consideration that something for something, capacity to contract, it means plus 18, sound mind, not disqualified by law. Willful consent should be there. If the basic feature is not fulfilled, the contract would be void and unenforceable. Okay? If the basic features are not fulfilled, the contract would be void and unenforceable. This is important. After that, there shall be the bailment of security. This is absolutely right because in the bailment, we are not giving any security, but in the pledge, we have to give the security against the payment and the performance of the promise. After that, the subject matter is always goods, that is a movable property. Goods pledged for shall in the existence. There shall be delivery of goods by the from the pledger to pledgee. Always remember, pawner, this is pledger, is equal to, this is pawnee, and this is pledgee. So this is the name of the party, that is important to remember. Any doubt, class? Any doubt in this one? So this is important from the examination point of view, the definition. Okay, very important. Please go through the points. Done? Now, let's do the question. Okay, let's do the question. That is important. Done? If you have any doubt, you can please ask in a comment box because now we will just understand the one concept and then we will do the questions. Okay, now the first question is the bailment of goods as security for payment of debt or the performance of promise is called what? Pledge, bailment, contingent contract, or agreement. What is the right answer? What is the right answer for this question, class? Tell me. And focus on the concept because concept clarity is very, very much important from the examination point of view. Yes, class. What is the right answer? Give me a quick reply. Give me a quick reply. The bailment of goods as a security for the payment of debt. This is absolutely called as the pledge. Okay. Section 172. This is the right answer. Okay. Now, in the pledge contract, bailee is called what? Powner, pawnee, pledger, none of the above. Tell me, class. Second one. What is the right answer? In the pledge contract, bailee is called what? What is the right answer? Bailee is called what? Just write the answer in the comment box. Write the answer. So in the pledge contract, the bailee is called pawnee. Okay, B is the right answer. Now, in the pledge, bailer is called what? Powner, pawnee, both AV or none of the above. What is the right answer? Everyone have to attend the class daily at 7:30 a.m. in which we are doing the module wise question. If you just tell you the plan of my YT session of the BRBL subject, now please focus in this. From December to February, we will do the module wise question. Okay, we will do the module wise question. After that, March, we will do the definition terms. Okay, then April, we will do the summary and the questions, and May, we will do the mini marathon plus marathon. Okay, and June your exam will be there. So this will be our plan for the YT session. Hello Bindu ma'am. So you are saying, Bindu ma'am, in pledge the bailer is called powner. You are absolutely right, ma'am. You are absolutely right. Excellent, ma'am. Okay, now pledgee is also known as what? Pawnee, powner, principal, or agent. Pledgee is also known as what? It's a pawnee, powner, principal, or agent. Okay, that's great, ma'am. The pledgee is known as the pawnee. Excellent, ma'am. A is the right answer. Okay. Pleasure is also known as, what is pleasure called? Pleasure is also known as what? Powner, pawnee, bailer, or agent. What is the right answer? Pleasure. So the pleasure is also known as the powner. So this is the right answer. Okay. So I think now the pledge is clear to all of you. Now, one thing I just want to remind you about the actual possession and about the constructive possession. You have to remember these two words, constructive, not construction. It's a constructive possession. and this is actual possession. Actual means that we are hand over, hand over the goods. This is called actual possession. And constructive, suppose we are giving the material of the go down. This is the go down, and we are giving material of the go down. Suppose it's contain 100 bag. So in the constructive possession, we cannot hand over the 100 bags of this one because this is also movable property, but we cannot give it to the this one bank. So we will just give the key of the go down. We will just give the key of the go down. So it means that is called as the constructive possession, that actually we are not handling the 100 bags of this one, but we are actually giving the key of the go down. So this is called constructive possession. So in the pledge, always remember constructive as well as actual, both will be come under the pledge. Okay, both will come under the pledge, contract of pledge. So this is important term. Hello everyone, a very good evening to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. So today in the morning we have just not done the session, so that's why we are doing session in the evening. So this is very important from the examination point of view. So before starting this session, I would like to say you that your resolution batch is already on the store. Okay, this resolution batch, as you can easily see, 4 compulsory subjects are there. Okay, in this batch there is a no elective subject. For elective subject, you have to select the recorded video course of elective subject. Okay, so this is the resolution batch. 4 compulsory subjects are there. It means you will get the live classes, you will get recorded session, you will get mock paper and doubt session, etc. So these are the things which are included in the resolution batch. Okay, if you want to enroll in this batch, you simply have to apply the coupon code, that is Y391, for the maximum discount up to 81%. So this is your about the batch. The next batch we will launch after the this one in the last week of January. Okay, so this is important from the examination point of view also. Now, module B is going on. Okay, now today we will just learn the 2 important terms. Okay, the first is lien and then second is set off. This is very, very much important. Now see, what is lien? Okay, what is lien? We have to understand it. Lien means a rights of a bailee to retain the goods and security owned by the bailior until the total debt due him is paid off. So one thing you have to remember in the lien is called retain. What is retain? Retain is basically to hold. Now see, first of all, why this word bailee and the bailior is used. We have to understand this one. Okay, why this word bailior and the bailee has been used. Now see, in the bailment what actually happened, A person deliver, no, B person give suppose 10 lakh rupees to A person, and A person is actually giving the movable property as a security to the B person. Movable property as a security to the B person. So you know the definition of bailment now. So now class, suppose if A person is called what? Bailor, and B person is called bailee. Right now, bailor and bailee. So in this case, the bailor and bailee, we can see that this is the movable property which is in the hand of B person. A have given only the possession, not the ownership. Okay. So now if A is not able to give 10 lakh rupees, so what will happen in this case? Now the B have a right to retain the goods and securities held by the bailee. B is a bailee owned by bailor. The ownership is still in the hand of bailiff until the total debt due is paid off. This is called lien clause. It allows the bailee and the creditor, because bailee give money and creditor give money, right to retain the security, not right to sell it. Sell is different thing. Sell is different. This is only right to retain the security. That's it. Okay, retain the security. So this is the actual definition of the term, that is lien. I hope so. This is clear. In simple term, lien means right to keep somebody's property until a debt is paid and not right to sell it to someone else. The bailee always has a right to lien against the bailiff. So this is very important. A bailee has a right to lien against the bailiff. Now try to understand this term, that is important one. That is important, guys. Please read the all paragraph. Please read the paragraph. Is that clear? Okay. If any doubt, you can please ask in a comment box. Okay, you can please ask in a comment box. Right? Now the next one. Particular and specific lien. C class. There are two types of lien. Okay, two types of lien. The first is specific and the second is the general lien. Now, what is the basic difference between these two? See, specific. First of all, Section 170 talks about the specific lien, the lien wherein a person who has made expenses either by rendering any service in the form of labor and skill on a particular item has right to retain such goods until the due remuneration is paid to him against the rendered service. The best example I will give you, see. A give his car to the mechanic for servicing against consideration of 4,500. The mechanic, after rendering the due scope of service, will right to keep the A's car in the custody until he is remunerated for his service. Exactly. The mechanic has spent 4,500 rupees on the car. So now this is a right of mechanic to take 4,500 rupees from the owner of the car, because he have given the services, and for that services the mechanic have a right to keep the A's car until the full payment is not done. This is called specific lien. So specific lien is always on the specific item. Always on the specific item. That is important. Specific item. A bailee can exercise his right to the particular lien in this one. See, there is an involvement of any labor and skill, performance of service as per agreed scope of service, and the payment is due made by the bidder. The payment is due that is made by the bidder. So this is the exact definition of the term, that is specific. Please read all the points. That is important. This is called specifically. This is called specific lien clause. Is that okay, class? Okay, so I think this is clear to all of you. Now let's start with the next one. What is journal lien? A lien whereby any goods bailed can be retained as security if any amount is due to the bailey. This is important. The best example, first of all, Section 171 talks about the journal lien. The examples are bankers, factors are the kinds of agent, warfingers, attorney of high court, and policy broker. So these are the examples of journal lien. So journal lien is basically where, suppose if I give you the example of banker. So banker can retain security, any property, till the full payment is not done by the customer. So this is called journal lien. So the bankers, attorney of high court, suppose the advocate of high court is there. If the client is not giving the full price of the servicing that is given by advocate, so the advocate have a right to retain all the documents which is given by the client. This is called journal lien. Is that okay? This is called journal lien. A very good example. Now see, what is set off? That is important. What is set off? So today we have done lien. Then we will also do the difference between the banker lien and the set off. Now, what is set off? Set off in one word you can say that is the right to balance debit with credit and a combination of account. What is this? Right to balance the debit with credit and a combination of account. This is called set off. A very simple example. So it is the legal right of a bank, okay, legal right of a bank to set off and adjust the debit amount against credit amount in the balance of the same borrower. Suppose the borrower have deposit some money, the borrower have to pay money. So this thing the bank will adjust. See the example. A buy a mobile phone from Y for rupees 10,000. Okay, letter. A sell to B Bluetooth headphone of rupees 5,000. A X buy a phone from Y phone. Okay, now A sell to B the Bluetooth headphone worth rupees 5,000. B is perfectly entitled to set off the cost of headphone against the liability for mobile needs to pay for 5,000 for the settlement exactly. Okay, so this is called set off. A very simple example to understand the set off. So it's a adjust the balance combination of account. Okay, this is the simple example. Now see the difference between banker's lien and set off. What is the basic difference between banker lien differ from right to set off? Lien is confined to only security and the property upon which the bank have a custody. Exactly. Liens means whatever we have given as a security to the bank, only on that property we have a right to lien. But a set off relates to money and may arise from contract or mercantile uses or by using law. That is important. Set off relates to money, may arise from a contract, mercantile uses by using the law. So this is best example to understand. Important point. Okay, so this is the important point. Any doubt? Okay, so this is the difference between this one. Now, what are the rights of lien? I will just tell you the famous case of lien and set off so that you can easily understand it. Wow, now, right to lien. The City Union Bank Limited versus Thangarajan. What is this? It was observed that the bank gets right of a journal lien with respect to all securities of a customer, including negotiable instrument, fixed deposit, but only to the extent to which that customer is liable. In the event that bank fails to return the balance amount to the customer and the latter suffer a loss thereby, the bank will be liable to pay associated damages to the customer. So lien, we know that that's specifically on the specific, security. Okay. So in this case, what the court absorbed? The court absorbed the bank gets right of journal lien with respect to all securities of a customer. And securities means when the customer give the things by taking money. So security includes negotiable instrument, fixed deposit, but only to the extent to which customer is liable. Suppose the customer is liable to pay 10 lakh, 15 lakh, only that amount we have to, only that security amount we have to kept. In the event bank fails to return the balance amount to the customer and later suffer a loss, so the bank will liable to pay the damages to the customer. That is important. That is important. Okay, this is important. In above case, the court has relied its decision on the principle which state that for invoking a lien by bank, there should exist a interdependency between bank and customer. Detaining the customer property beyond the total liabilities unauthorized would attract the damages. Please see. Okay, class. So this is your right to lien. Okay. The bank only have to retain that much of property that's required. Okay. Otherwise, the bank have to pay the damages. And what is damages? Damages is the compensation. Damages is the compensation. Okay. Now, right to set off. What is the case name? The case name is Radha Raman Chaudhary and other versus Chota Nagpur Banking Association Limited. In this case, the plaintiff father had a fixed deposit with the bank and also executed 4 hand notes jointly with a certain person in the favor of bank. Plaintiff father did, and the fixed deposit account was transferred to the name of plaintiff on their undertaking of all the liabilities of their father to bank. The bank, without the knowledge of plaintiff, adjusted the fixed deposit against due. The plaintiff filed a suit against bank claiming the amount of deposit which has been adjusted. So this is called right to set off. A very simple example. Okay, because we know that the plaintiff is there, but obvious he just appoint the nominee. The son is a nominee, so he can easily adjust. The bank can easily adjust this thing. So this is called right to settle. Please read the example. That is important. That is important. Okay, class. So this is your particular this one. Okay, so that's, you can say they contended that the father was merely a surety for other executant of the notes, not a principal debtor. Okay, so High Court make a clear distinction between lien and set off. That 171 of Indian contract made in this case, it was held that bank have a right to merge one and more account of the same customer, but bank cannot combine the customer personal account with a joint account of customer and another party. This is very important for your this one.
Hello everyone, a very good afternoon to all of you. Welcome to the Officer Adda channel of Adda 24/7. Myself, Advocate Nikita Singh. I'm your legal mentor, and right now we are doing the questions of Module B, which is very much important. Before starting this session, I would like to say you that this is our resolution batch of CAIIB June 2024, which is already started from 10th of January. In this batch, you will get the live classes of all the compulsory subject. Second point, if you are not able to see the live classes, you can just get the recorded session. You will get the mock paper here, doubt session, etc. So this single paid batch plus one, that is the one elective video course you have to select. Because right now we don't have any live class of elective paper, we have a recorded video course. So if you purchase this single batch plus video course of elective subject now, you will get the complete package. But if you want everything in one batch, so for this thing you have to purchase the CAIIB ka Mahapack, which is important. Okay, now let's start the session. Module B is going on. Today we are going to start the questions of Negotiable Instrument Act. Number one question. The negotiable instrument, first of all, we have to understand what this exactly means. Negotiable means transfer, and instrument means that is the document. Okay, before, we just generally do the barter system. Before, we just do the barter system for exchange of the goods. After that, the rupees come into picture, okay, gold, something, and then document come into picture. So document basically in which we can just transfer the money from one person to another person, okay. So Negotiable Instrument Act is an act to define and amend the law relating to what? Check, bill of exchange, promissory note, all of the above. So you have to tell me in the Negotiable Instrument Act, okay, what type of document we have to study. Whether it is check, bill of exchange, promissory note, or all of the above. Which of the following is the right answer for this question? Hanji class, tell me. So class C, the Negotiable Instrument Act basically deal with the check, section 6, bill of exchange, section 5, promissory note, section 4. Okay, so all of the above is the right answer. First one, this is the right answer. Okay, okay. Now the next one. Next question is, in promissory note, how many parties are involved? Promissory note. So for this thing, you have to learn about what is promissory note. See, suppose A is the person, B is the person. A have given goods to the B person, and now B person have to give 5 lakh rupees to the A person. Okay, 5 lakh rupees. Now in this case, what will happen? If I say you, so B person is making a document. That document is promissory note. That document is promissory note. Okay, so in the promissory note, what will happen? B will write that I will give you the money of A, 5 lakh rupees at this date. So you have to define here the date and the particular time. Done. So B is called maker, and maker we also call as the drawer. To whom? To A person. So A is called the pay because A wants money. So in the promissory note, guys, there are two parties in this one. And every promissory note, always remember, it must be registered and stamped. Registered and stamped. This is important one. Registered and stamped. So parties, there are two parties in the promissory note. Second is the right answer for this question. Okay, this is the right answer. Then guys, next. What is not correct about the promissory note? It contains conditional undertaking. It contains amount mentioned on it. It is instrument in writing signed by the maker. So now just remind the definition and tell me which of the following is not correct about promissory note. Tell me class, what is the right answer? Hanji class, if you see the section 4 of the Act of NI Act, you will get the definition. You will get the definition. So what is the right answer? Correct about promissory note. Amount mentioned, this is absolutely right. Writing, yes. Signed by maker, yes. This is not the right answer because it is the unconditional. This word is wrong. Unconditional word will be there. So for the third one, first is the right answer. Not correct. So first is not correct for this question. Is that okay, class? Done? Now, next. Section 5. Deal with what? Bill of exchange, holder in due course, check or promissory note. Section 5. Section 5 deal with bill of exchange, holder in due course, check or promissory note. So section 5 is basically class bill of exchange. If I give you the example of bill of exchange, A, this is B. Again, A is giving goods to the B person and B is giving, no, in this one, what will happen? A is giving goods. So B have to give the rupees, that is of 5 lakh rupees. Okay. Now in this case, what will happen? The A will make the bill of exchange. And he will write that B will give 5 lakh rupees to the C person. So C is the another person. After this, now, first of all, A will sign here. A will sign here, okay, and then after it will go to the B person. So after that, B will also sign here, and then it will go to the C person. So in this case, you can see A is the maker and drawer, and B is the drawee. He have to give the money, and C is the pay. Some student asked that, ma'am, is A is equal to C? The answer can be right. Exactly. A can be the C person. So this is the exact answer. Section 5, deal with the bill of exchange. Any doubt, class? Okay, this is the right answer. Okay, this is the right answer for this question. Next, in appeal by the drawer against conviction, the appellant court may order appellant to deposit the sum of dash minimum compensation awarded by the trial court. Okay, this is your trial court. If trial court have given decision, you are not satisfied, you will go to the appellant court. So how much percentage of amount you have to pay? 10% of fine, 15% of fine, 20% of fine, or 25% of fine? What is the right answer? What is the right answer for this question? Whether it is 10%, 15%, 20%, 25%. How much percentage? Suppose if any appellant is there, how much percentage he have to pay to this one? 10, 15, 20 or 25%? This is very important question. This is very important question. $10, 15, 20, 25%. So for this one class, 20% is the right answer. Okay? Now, in the interim compensation, what is interim compensation? That is the temporary. The temporary compensation payable under section 143A, this is a new section which is added in the NI Act, may be recovered as if a fine. As per CRPC, as per income tax, or as if it is decree of the court. What is the right answer? Under section 421 of the CRPC. This is the right answer. Okay, 6. And what is exactly, see, Income Tax Act, you know, let's talk about the tax. But this is the act whose short name is CRPC. So CRPC is basically a criminal law which talks about the procedure that follow in the criminal cases. Procedure that follow in the criminal cases. So this is the sixth one. Okay. Now, all offences under chapter 17 shall be tried by Metropolitan Magistrate, Judicial Magistrate of first class, either A and B or none of the above. Metropolitan Magistrate always, where population is more than 10 lakh rupees, this is there, and 10 lakh low, this is there. Tell me, class, what is the right answer? All offences shall be tried by what? What is the right answer? All offences under chapter 7 shall be tried by what? What is the right answer for this question? So, either A and B. C is the right answer for this question. Okay, now, which court can entertain any offence punishable under section 138? What is section 138? Talks about dishonor of check. Court not interfere to that judicial magistrate of the first class. Any court having jurisdiction may entertain such case. Court not interfere to that metropolitan magistrate. Option A, C is correct. What is the right answer? Right now we have just done. Right now we have just done. The right answer will be this and this. What are the liabilities of collecting banker? What is collecting banker? A person is there, B person is there. A have given check of 10 lakh rupees to the B person. Okay, A have given the check of 10 lakh rupees to the B person, right? B will go to the bank, right? This is bank 1 and A's bank is bank 2. So now this A1 bank that will deposit check to here, collect the money from here. So this is called paying bank, because bank 2 have to pay, and this is the collecting bank. This is the collecting bank. So the right answer is liabilities of collecting banker: to serve notice of dishonor on the customer so that customer can claim amount, to present check within the reasonable time, to hand over the proceed after the realization without delay, and all of the above. What is the right answer? So class, for this one, the right answer is all of the above. Now, In which section negotiable instrument is defined? Yes, class. In which section negotiable instrument is defined? What is the right answer for this question? Negotiable instrument is defined 15, 14, 13A or 13. What is the right answer? The section which define the negotiable is 13. But always remember, it's not defined the exact meaning of Negotiable Instrument Act. It say that it include promissory note, bill of exchange and check. So this is the definition of promissory note. So for this thing, the right question is 13 is the right answer for this question. Is that okay? Any doubt? So this is very, very much important from the examination point of view. Now see. If you want to enroll in a particular batch, so what you have to do? First of all, Adda 24/7, you have to open the Adda 24/7 site. Okay, then click on all courses. If you click on all courses JIB CAIIB, this is your JIB CAIIB ka Mahapack. As you can easily see, JIB CAIIB ka Mahapack. This is CAIIB June 2024. So if you want to purchase a single batch, you can click here. If you want to purchase the CAIIB Mahapack, this is your CAIIB Mahapack 2.0. If you click on this, first of all, see, all the live classes are there. C class. All the live classes. It's a ABFM, BRBL subject, ABFM bilingual, BFM bilingual, BRBL, then it's a BFM. You can see here. Everything is there. Everything is there in this batch. Okay. So what you have to do, you have to click on this. If you want to purchase it now, the price is very nominal. What you have to do, click on buy now. If you click on buy now, enter the coupon code Y391. If you click on this one, you can see here the discount is 77%. So for the 6 month, the price will be 7,473. So in this Mahapack, you will get every batches that we will launch, every batch. Okay, plus marathon and mini marathon. Okay, then you will get the this one, the all elective paper video courses, and before exam we also launched the revision batch of this. So you will get it. Okay, so this is all about your batch. And if you want a single batch, you can purchase a single batch. For single batch, resolution. Buy now, click here, Y391. Apply 77%. This is of the single batch. Thank you so much for updating the class.